Roberto and Ricardo have had a long-standing dispute regarding conflicting claims over the ownership of a parcel of land. One night, Roberto was so enraged that he decided to kill Ricardo. Roberto asked his best friend, Rafael, to lend him a gun and drive him to Ricardo's house. Rafael knew about Roberto's plan to kill Ricardo, but agreed to lend him a gun nevertheless. Rafael also drove Roberto to the street corner nearest the house of Ricardo. Rafael waited for him there until the task had been accomplished so that he could drive Roberto to the next town to evade arrest. Roberto also asked another friend, Rule, to stand guard outside Ricardo's house for the purpose of warning him in case there was any danger or possible witnesses, and to keep other persons away from the vicinity. All three, Roberto, Rafael, and Rule, agreed to the plan and their respective roles. On the agreed date, Rafael drove Roberto and Rule to the nearest corner near Ricardo's house. Roberto and Rule walked about 50 meters where Rule took his post as guard, and Roberto walked about 5 meters more, aimed the gun at Ricardo's bedroom, and peppered it with bullets. When he thought that he had accomplished his plan, Roberto ran away, followed by Rule, and together they rode in Rafael's car where they drove to the next town to spend the night there. It turned out that Ricardo was out of town when the incident happened, and no one was in his room at the time it was peppered with bullets. Thus, no one was killed or injured during the incident. A. Was a crime committed? If yes, what are the crimes committed? B. If a crime was committed, what is the degree of participation of Roberto, Rafael, and Rule? Suggested answer. A. Yes. In the case of Intod versus Court of Appeals, GR number 103119, October 21, 1992, the Supreme Court ruled that when factual impossibility occurs because extraneous circumstances unknown to the actor were beyond his control, rendering the intended crime impossible of accomplishment, the offense committed is an impossible crime. Article 4, Paragraph 2, Revised Penal Code. The factual situation that made impossible the accomplishment of the crime intended when they peppered Ricardo's room with bullets was the physical absence of the intended victim of the room. B. All the perpetrators, Roberto, Ricardo, and Rafael, are criminally liable as principals since the conspiracy among them was clearly established by their participation. Roberto is principal by direct participation as he took a direct part in the execution of the plan to kill Ricardo by firing his gun at the room of the intended victim. Rafael is principal by indispensable cooperation not only because he lent his gun to Roberto fully knowing the unlawful intent of the latter, but also drove him to the place of the commission of a crime and to a place where he could escape. Rule, being involved in the criminal plan to kill Ricardo, acted in conspiracy with the two other perpetrators staying in the place from the time they planned the crime up to its finalization. They were together in the car driven by Rafael going to the next town and escaping from the scene of the crime. Two. Rico, a hitman, positioned himself at the rooftop of a nearby building of a bank to serve as a lookout for Red and Rod while the two were robbing the bank, as the three of them had previously planned. Ramiro, a policeman, responded to the reported robbery. Rico saw Ramiro and, to eliminate the danger of Red and Rod being caught, pulled the trigger of his rifle, intending to kill Ramiro. He missed as Ramiro slipped and fell down to the ground. Instead, a woman depositor who was coming out of the bank was fatally shot. After their apprehension, Rico, Red, and Rod were charged with the special complex crime of robbery with homicide. Rico's defense was that he never intended to shoot and kill the woman, only Ramiro. Red and Rod's defense was that they were not responsible for the death of the woman as they had no participation therein. A. Is Rico's defense meritorious? B. Is Red and Rod's defense meritorious? Suggested answer. A. Rico's defense is not meritorious because the homicide was committed on the occasion of a robbery. Thus, the crime committed is robbery with homicide as long as the killing occurred on the occasion of the robbery, whoever be the victim, whether intended or not. B. No, the defense of Red and Rods is also not meritorious. The concerted manner in which the three, Rico, Red, and Rod, perpetrated the crime showed clearly the presence of conspiracy. When a homicide takes place by reason or on the occasion of a robbery, all those who took part shall be guilty of the special complex crime of robbery with homicide, whether or not they actually participated in the killing. Regardless of the fact that the killing of the woman depositor was individually performed by Rico, the basic principle in conspiracy is that the act of one is the act of all. The criminal liability of Rod and Red is one and the same with that of Rico. People v. Hinlow, GR number 212151, February 18, 2015. Three. On February 5, 2017, Rio fraternity held initiation rites. Present were Redmont, the Lord Chancellor and head of the fraternity, 10 members, one of whom was Rick, and 5 neophytes, one of whom was Ronald. Absent were Raleigh, the fraternity's vice-chancellor and who actually planned the initiation, and Ronnie, the owner of the house where the initiation was conducted. Due to the severe beating suffered by Ronald on that occasion, he lost consciousness and was brought to the nearest hospital by Redmont and Rick. However, Ronald was declared dead on arrival at the hospital. During the investigation of the case, it was found out that, although Ronald really wanted to join the fraternity because his father was also a member of the same fraternity, it was his best friend Rick who ultimately convinced him to join the fraternity and, as a prerequisite thereto, undergo initiation. It was also shown that Redmont and Rick did not actually participate in the beating of the neophytes. The two either merely watched the hazing or helped in preparing food. And, lastly, 2 days prior thereto, Ronnie texted Raleigh that the fraternity may use his house as the venue for the planned initiation. Aside from those who actually participated in the hazing, Redmont, Raleigh, Rick, and Ronnie were criminally charged for the hazing of Ronald that resulted in the latter's death. A. Are the 4 criminally liable? B. Can all those criminally charged be exonerated upon proof that Ronald, knowing the risks, voluntarily submitted himself to the initiation? Will the absence of proof that the accused intended to kill the victim affect their liability? Suggested answer. A. Yes. Redmont's presence during the hazing is prima facie evidence of participation therein as principal, unless he prevented the commission of the hazing that caused physical harm to Ronald. Rick is also liable criminally, because as member of the fraternity who knowingly cooperated in carrying out the initiation by inducing the victim to be present thereat is liable as principal. He is penalized, not because of any participation in the infliction of harm to the victim, but due to his indispensable cooperation in the crime by successfully inducing or convincing the victim to undergo the hazing. Raleigh, as vice-chancellor of Rio fraternity, who actually planned the initiation though not present when the acts of hazing were committed, is liable as principal. Ronnie, the owner of the place where hazing was conducted, is liable as accomplice, because he had actual knowledge of the hazing conducted therein and failed to take any action to prevent occurrence of the same. Section 4 of RA 8049, Anti-Hazing Law, as amended by RA 11053, Section 14, owner of place is liable as principal. Dungo and Sybil, Jr. vs. People, GR number 209464, July 1, 2015. B. The defense of consent will not apply, because the very act of inflicting physical pain or psychological suffering is, by itself, punishable. That it resulted in the neophyte's death or physical injuries merely aggravates the act, resulting in the imposition of higher penalty. Also, RA 8049, the anti-hazing law, is malum prohibitum, thus existence of criminal intent is immaterial. For on the way home from work, Rika lost her necklace to a snatcher. A week later, she saw what looked like her necklace on display in a jewelry store in Rayon. Believing that the necklace on display was the same necklace snatched from her the week before, she surreptitiously took the necklace without the knowledge and consent of the store owner. Later, the loss of the necklace was discovered, and Rika was shown on the CCTV camera of the store as the culprit. Accordingly, Rika was charged with theft of the necklace. Rika raised the defense that she could not be guilty as charged because she was the owner of the necklace and that the element of intent to gain was lacking. What should be the verdict if A. The necklace is proven to be owned by Rika? B. It is proven that the store acquired the necklace from another person who was the real owner of the necklace? Suggested answer. A. Under Article 308 of the RPC, theft is committed by any person who, with intent to gain but without violence against, or intimidation of persons nor force upon things, shall take personal property of another without the latter's consent. While the CCTV captured Rika surreptitiously taking the necklace from a jewelry store without the knowledge and consent of the store owner, she cannot be charged with theft because the taking was made under a claim of ownership. The fact of ownership negates any intention to gain, as Rika cannot steal the necklace which she claims to own. B. Even if it was proven that the necklace was bought by the store from another person who was the real owner of the necklace, Rika still cannot be held liable for theft absent of felonious intent.
Actus non facit rem, nisi mens sit aureae.
A crime is not committed if the mind of the person performing the act complained of is innocent. The ruling in U.S. v. Vera, 1 Phil 485, May 31, 1974, is emphatic. Example: if a person takes personal property of another believing it to be his own, the presumption of intent to gain is rebutted and therefore he is not guilty of theft. With a promise of reward, Robert asked Romy to bring him a young girl that he, Robert, can have carnal knowledge with. Romy agreed, seized an 8-year-old girl, and brought her to Robert. After receiving his reward, Romy left while Robert proceeded to have carnal knowledge of the girl. A. For what felony may Robert and Romy be charged? B. Will your answer in A be the same if the victim is a 15-year-old lass who was enticed, through cunning and deceit of Romy, to voluntarily go to the house of Robert where the latter subsequently had carnal knowledge of her? Suggested answer. A. Robert may be charged with the crime of child prostitution or other sexual abuse under Section 5, B, of RA No. 7610, Special Protection of Children Against Child Abuse, Exploitation and Discrimination Act, by having sexual intercourse with a child exploited in prostitution. Because the victim was under 12 years of age, in this case, 8 years, Robert should be prosecuted under Article 266, A and 266, B of the Revised Penal Code as amended by RA No. 8353, Anti-Rape Law of 1997. Romy, on the other hand, may be charged with the crime of child prostitution or other sexual abuse under Section 5, A, of RA number 7610 by acting as procurer of a child prostitute. B. Yes. RA number 7610 covers sexual abuse committed against a child or children below 18 years of age. Children who for money, profit, or any other consideration due to the coercion or influence of any adult, syndicate, or group indulge in sexual intercourse or lascivious conduct are deemed to be children exploited in prostitution and other sexual abuse. Robert and Romy may be prosecuted under the said law.